The judge glanced up from her documents and arched an eyebrow. "You're saying they aren't even part of your home?" she inquired, her tone laced with that unique courtroom skepticism that makes attorneys nervous. From the other side of the room, Karen Piletin faltered, her complexion turning ashen under her impeccably coiffed bob hairstyle. "Well, Your Honor, technically the boundaries are a bit unclear, and we feel that historically the purpose was always to encompass all nearby homes within the Maplewood Heights HOA authority. Moreover, we possess records indicating that prior residents might have orally consented to specific neighborhood rules that would suggest an implicit agreement to HOA oversight. And additionally," the courtroom whispers intensified as I steadily pulled a document from my briefcase and set it on the desk. "The property survey map is authentic, verified, and undeniable, Your Honor," I stated softly. "This is the certified county plat. My land is precisely 112 feet beyond the HOA limit." The judge examined it for precisely 7 seconds. "Case thrown out with prejudice. Mrs. Piletin, you're covering all court expenses." The beginning of the battle. Let me rewind and explain how it all began. 6 months prior, I relocated to my ideal residence, 5 acres of forested bliss, featuring a surrounding creek and the sort of serenity that's priceless. The land was at the terminus of a lengthy dirt path, officially on Elm Street but essentially in its own secluded realm. Right past my eastern boundary, the uniform suburbia of Maplewood Heights commenced, with its identical dwellings and flawlessly groomed yards. All was ideal for precisely 3 days. That's when Karen arrived. I was sorting crates in my garage when I caught the crisp click, click, click of stilettos on cement. I pivoted to spot a woman in her 50s, attired as if en route to a business conference instead of strolling through a countryside area. She held a bulky envelope and sported a grin that failed to touch her eyes. "Welcome to the area," she trilled, though her inflection implied she was far from pleased to encounter me. "I'm Karen Piletin, head of the Maplewood Heights HOA. I've prepared our introductory package, neighborhood regulations, and your initial dues bill." I cleaned my hands on my pants and took the envelope, more from courtesy than curiosity. "Appreciate it, but I believe there's an error. I don't reside in Maplewood Heights. This is Elm Street and we're not affiliated with any HOA." Her grin stiffened. "Oh, I believe you'll discover that every lot in this vicinity is under our control. We've recently broadened our limits to guarantee uniform community standards." I couldn't suppress a laugh. "Ma'am, you can't simply broaden boundaries. That's not how real estate law operates. I deliberately selected this home because it lacked an HOA." "Well," she replied, her voice acquiring a sharpness keen enough to slice through steel, "we'll determine that. Meanwhile," she observed, "your mailbox isn't standard black. You'll have to swap it in 30 days or incur a $50 penalty." "My mailbox is on my land, which isn't in your HOA," I reiterated deliberately, like instructing a youngster. "Enjoy your day, Mrs. Piletin." She lingered there briefly, evidently unaccustomed to being brushed off. Then she whirled around and strode back to her domain, her stilettos tapping a furious cadence on the asphalt. The escalation. I figured that would conclude it. I was mistaken. The following morning, I discovered a vivid orange infraction slip affixed to my mailbox, non-standard mailbox hue, penalty $50 payable in 15 days. I balled it up and discarded it in my recycling container. 2 days on, another slip materialized, this one for overabundant wild greenery. Evidently, my choice against installing turf on my treed land breached neighborhood norms I wasn't bound by. The slips continued arriving: unauthorized fence shade, a leisure vehicle observal from the road, my classic truck, and evidently neglecting to uphold proper turf elevation in a zone that was actually woodland ground blanketed in pine straw. Each slip went directly into my expanding dossier marked proof of pestering. Matters intensified when I opted to construct a shed in my rear yard. I possessed all the appropriate county approvals. Naturally, everything was fully lawful and compliant. But that didn't deter Karen from appearing with 2 fellow HOA officials trailing her. "You can't erect that without HOA sanction," she declared while I was placing the base pillars. "Fortunate I don't require HOA sanction," I responded, not pausing my labor. "I'm cautioning you," she stated, her pitch escalating. "If you proceed with this unsanctioned building, we'll be compelled to pursue judicial measures." "Please proceed," I said composedly. "I'd relish watching you justify to a judge why you believe you hold sway over land you don't control." Her visage shifted to a fascinating tint of violet. "You believe you're so clever, don't you? Well, allow me to inform you, Mr. Dalton, I've managed this HOA for 12 years. Nobody challenges me and escapes unscathed. Nobody." "I'm not challenging you," I noted sensibly. "I'm merely residing on my own land, you know, the land that isn't in your HOA." She departed in a huff, but not before capturing images of my building endeavor with her device. I gestured at the lens and resumed my tasks. The gossip network was a marvel. Following that, I'd catch murmurs when visiting the nearby supply shop. Evidently, Karen had been informing whoever would heed that I was a troublesome resident, diminishing land worth and declining to join the group. The amusing part was that I truly bonded well with the genuine Maplewood Heights dwellers neighboring the divide. A few had discreetly noted that they believed Karen was overstepping, though none desired to voice it openly. Karen had a notoriety for complicating existence for anyone who opposed her. Then arrived the correspondence from her lawyer. I enclose that in quotes since I'm 90% certain she penned them personally. They brimmed with legal terms employed wrongly and ambiguous warnings regarding seeking all accessible legal recourses. I began maintaining a thorough record, every exchange, every slip, every missive. I also set up surveillance devices ideally situated to record any forthcoming appearances by Karen or her followers. The lawsuit and the showdown. The registered mail came on a Tuesday, a genuine legal action. Karen Pileton and the Maplewood Heights HOA were litigating against me for neglect to remit HOA fees amounting to $3,600. Numerous breaches of neighborhood norms leading to $5,000 in penalties. Harm to community land values demanding $20,000 in compensation. Attorney charges and judicial fees. The action asserted that my land had been erroneously omitted from the initial HOA limits owing to an administrative mistake, and that this lapse was presently being rectified. Most folks would have freaked out, I chuckled. Then I contacted my cousin Janet, who was incidentally a property lawyer. "She really filed suit against you?" Janet questioned after I detailed the scenario, "for land that's not in her HOA." "Yep, she's asserting it was erroneously omitted." Janet's chuckles reverberated over the line. "Oh, this will be entertaining. Forward me all you've collected." I went beyond that. I headed to the county archives department and obtained authenticated duplicates of every pertinent record. The initial survey diagram from the HOA establishment, the lawful outline of my land, the HOA's founding documents which explicitly outlined their limits, map data extending back half a century. It was all documented plainly in ink. My land had never belonged to the HOA. There was no administrative slip-up. There was no uncertainty. Karen had merely resolved that she desired to enlarge her small empire, and she'd picked me as her initial target. The hearing day came sooner than anticipated. I appeared in my finest attire, portfolio in hand, feeling remarkably composed. Janet had proposed to advocate for me, but I chose to defend myself. This was intimate. Karen showed up with a group, 2 additional committee members, an individual who could have been a legitimate attorney, and sufficient documents to stuff a storage unit. She donned a business outfit that shouted, "I insist on seeing your supervisor," and a self-satisfied look that implied she'd already triumphed. The judge, the esteemed Patricia Wung, appeared weary, prepared for her commencement. I sensed she'd handled HOA conflicts previously. Karen's team proceeded initially. Her attorney, he was an authentic lawyer, it emerged, although not a particularly skilled one, embarked on an extended discourse regarding the essence of neighborhood unity, the significance of upholding norms, and the HOA's conviction that my land ought to have been incorporated in the primary borders. He submitted displays, numerous displays, images of my shed, replicas of infraction alerts, a manually sketched diagram that seemed crafted with markers, and statements from committee members concerning the value of uniform administration. What he omitted was any genuine lawful foundation for their assertion. When my opportunity arrived, I rose and unlocked my portfolio. "Your Honor, I possess merely one display." I positioned the authenticated survey diagram on the judge's platform. This is the formal county assessment from 1997 when the Maplewood Heights HOA was established. As is evident, my land, lot number 473,891, is distinctly indicated beyond the HOA confines, 112 feet beyond to be precise. The judge scrutinized the diagram attentively. Mrs. Pileton, do you possess any proof that refutes this formal assessment? Karen rose so abruptly that she toppled her water tumbler. Your Honor, we maintain that the initial purpose was to incorporate all adjacent lands, and additionally, I didn't inquire about convictions or purpose, the judge cut in. I inquired whether you have any proof that refutes this formal assessment. Karen's attorney murmured hastily in her ear. She dismissed him and continued speaking. The issue is, Your Honor, this individual has been intentionally sabotaging our neighborhood norms. He constructed an unsanctioned building. He declines to upkeep his land per our directives, and he's been motivating other dwellers to challenge HOA power. Because I don't reside in your HOA, I stated serenely, I can't sabotage a power that doesn't pertain to me. The judge's demeanor was invaluable. She glanced from Karen to me, then back to Karen. Mrs. Pileton, are you genuinely informing me that you initiated legal action against someone for breaching HOA regulations when they don't reside in your HOA? It's the concept of it, Karen exclaimed. If we permit individuals to simply act as they please directly adjacent to our neighborhood, it establishes a risky example. The risky example, the judge articulated deliberately, would be permitting an HOA to impose regulations on land they don't oversee. Mr. Dalton, do you have any opposing demands? Yes, Your Honor, I'm pursuing reimbursement for pestering, baseless legal proceedings, and attorney expenses. The judge affirmed, I've observed sufficient. This matter is rejected with finality. Mrs. Pileton and the Maplewood Heights HOA lack jurisdiction to apply any regulations or impose any penalties on Mr. Dalton. Moreover, this legal action constitutes an evident instance of pestering and misuse of the judicial process. She pivoted to confront Karen squarely. Mrs. Pileton, you are individually responsible for Mr. Dalton's attorney expenses and judicial fees. In addition, I'm levying a penalty of $5,000 for baseless legal action. Any additional efforts to pester Mr. Dalton will lead to felony accusations. Do I express myself distinctly? Karen's lips parted and shut like a stranded fish. No voice emerged. I'll interpret that as affirmative, the judge declared. Session is concluded. Tranquility restored. The entire affair had lasted under 3 minutes from the instant I submitted the survey diagram. I exited that courtroom feeling justified. Karen staggered out after me, her group dispersing like rodents from a foundering vessel. Her complexion had transitioned from violet to pale to a kind of greenish, ashen tone I'd never witnessed on a person previously. A week afterward, I was savoring my dawn brew on the veranda when I spotted someone approaching my path. I stiffened, prepared for another clash, but eased when I identified Tom Bradley, one of the Maplewood Heights inhabitants I'd become amicable with. Morning, Tom, I shouted. Coffee. Thanks, but I can't linger, he replied, ascending the veranda stairs. He extended an envelope. Desired to deliver this to you directly. I unsealed it to discover a formal request. Termination of the MAPLEWOODHEIGHTS Association was inscribed at the summit in prominent text. Beneath were numerous endorsements. Following the court incident, folks began conversing, Tom clarified, about how Karen's been managing affairs like her private domain, the unwarranted penalties, the biased application, and the coercion methods. We reasoned that if she could pursue someone who doesn't even belong to the HOA, what might she do to the remainder of us? I reviewed the endorsements. Over 60% of the property owners had endorsed. We're scheduling an extraordinary gathering next week to vote on termination, Tom proceeded. Karen's already been ousted from the committee. It emerged she'd been utilizing HOA resources for her individual legal costs. That was the ultimate trigger. I returned the request. I can't endorse this. I'm not a participant. Tom smiled. We understand, but in some way you accomplished what none of us could. You toppled Karen Pileton from beyond the HOA. As he strolled back along my path, I couldn't resist grinning. I'd relocated to this land for tranquility and silence. I'd encountered a half-year conflict with an authority-obsessed HOA leader instead, but ultimately I preserved my tranquility and silence, and the area had achieved its liberation. Not terrible for someone who never even enrolled in the HOA. The ultimate count arrived a month later. The ballot to terminate succeeded with 78% endorsement. Karen's judicial issues were merely commencing. The State Prosecutor General's Bureau had initiated a probe into abuse of HOA resources. She'd been dismissed from her role at the property agency where she was employed after reports of the legal action spread rapidly on online platforms. The final update I received: she was facing up to 5 years of incarceration for fraud and $30,000 in penalties. When the detectives arrived to question me, they noted she'd collapsed sobbing when they presented her with the proof, claiming she'd solely desired to uphold norms.